Hi, Jim Garrity here. The purpose of this audio and video is to help you get ready for your deposition. It's just the first step, so watch it, take notes, ask me questions if you have any. Keep in mind when you have your deposition that it's not a social conversation. It's sworn testimony. There'll be other lawyers in the room. There'll be a court reporter taking down every word, and everything that you say is down forever. So it's not a social conversation. It's not a chance to lecture about things that have been bothering you. It's not a free exchange of ideas. When you have your deposition, you want to keep in mind a couple of basic rules. One, if you know the answer, tell it fully and completely. You never want to be in a position where you are leaving out information that you know is true and that you can recall during the course of the deposition. On the other hand, if you don't know an answer, the correct response in sworn testimony is to say you don't know rather than guess. And if you knew it at some point, it's not something you never knew, but if you knew it at some point and as you're sitting there in your deposition you can't recall it, then simply say you don't remember. There are key differences between a social conversation and sworn testimony, and this outlines some examples of how we might answer a question in a social conversation as compared to deposition testimony. In a social conversation, we want to keep the dialogue going. We want to be friendly and chatty. In a deposition, we want to be precise and accurate. We want to keep the answers focused on the question, and it means listening carefully to the question and then answering that question and that question only and waiting for the next one. Again, it's not an opportunity to be chatty and to show how much you know about a given topic. It's simply an opportunity to answer the questions one by one as they're asked. As you'll hear me say over and over again, every answer counts, every word counts. If you know the answer, you must answer the question fully and completely. But again, there's no obligation to go beyond the question. If it makes sense in certain circumstances to provide some additional background information, that's fine. But on balance, when you're answering questions in a deposition, you want to focus on that question, answer that question, wait for the next one. The example I always give is a baseball player out on the in the batting area waiting for a pitch. He's going to swing at one pitch at a time, and that's what you want to do in a deposition. One pitch, one swing. You don't want to anticipate questions coming down the road. You don't want to try and answer some questions that you think are probably coming. Focus just on the question that's being asked and leave it at that. Again, if you don't know the answer, the correct thing to say is you simply don't know the answer. Don't take a guess at it. Guesses will count against you as real answers, no matter what you say. And if you don't remember something, simply clearly say, as I sit here right now, or some variation of that, I don't recall. Another key issue that comes up in deposition is this: what to do about documents. Depositions are often conducted at a fairly swift pace. The questions often come fairly quickly, and you'll sense some pressure to answer the questions just as quickly. That can be a problem when you're presented with documents which in some cases are very thick, such as an employee handbook or a personnel file or a set of policies and procedures, or maybe a compilation of a variety of emails. You've got to look at each document carefully, one at a time, from the top left corner to the bottom right. And you've got to be doubly sure when you say, yes, this is a true and correct copy of my application or of an email I filled out or of a reprimand that I got, that it's absolutely correct. Once you say the document is true and correct, it's likely going to be shown to the judge later outside your presence with a representation by the lawyer that you swore that that document is accurate. So be extremely cautious when looking at documents in deposition. This is a perfect example of a handwritten document that witnesses commonly see in depositions. You've got to take a look at it, starting with the very first piece of information that appears in the upper left corner, and go line by line to ensure that when you're done looking at it, when you say, yes, this is a true copy of a reprimand or something out of my personnel file, that you're not going to have to come back later on and say, I didn't look at it, I wasn't cautious in my deposition. I didn't spend the time that I needed to carefully review it. So take a look at it and ask yourself, is there any handwriting on this document that wasn't there or that I'm not sure was there when I signed it? Is there anything that I wrote down that's now missing? Are there boxes that were checked back at the time that have been whited out now, or vice versa? Are there boxes that were checked at the time or weren't checked and now are? Is there handwriting that appears out of place on a line or that appears to be outside the margins? Is there anything at all about the document that raises doubts? Even if there isn't, you still want to make doubly sure that you're certain that the document is true and correct before you swear to that. Again, these documents will be used later on against you, and you will not have an opportunity later to come back and say, Judge, I didn't look at it. I now see that there's something different. Once you've sworn under oath that it's accurate, that's the testimony you're stuck with. Now, this is another perfect example of problems that come up with documents. You've got to make sure that you look at every page, even if the document has 500 pages in it. If you're presented with a copy of your employee handbook, essentially what I would say to a lawyer under these circumstances is, if you want me to swear that this is the employee handbook that I got, I've got to go through every page. And even then, I may not be able to attest to the truthfulness of this document without comparing it to a version that I have. Sometimes lawyers will say, well, your lawyer produced this copy of the handbook as something that was in your possession after you left the company. How can you not recognize the handbook that you provided to us? And many witnesses will say, well, once it left my hands, it went to my lawyer's hands and it went to you, and so you represent the company. I can't be certain now that there haven't been changes to this document. I just can't say that. The law doesn't require you to simply go along with what might seem to make sense in a deposition. It's your sworn testimony and no one else's. No one else in the room will be under oath, so you've got to stand your ground, take your time, look at documents. Never agree that a document is genuine just for the sake of agreeing. All right, let's talk just for a second about the common questions you're going to get. The fact is, in most employment discrimination cases, retaliation cases, the core questions that a witness is going to be asked, that the person who's suing is going to be asked, are very similar. It doesn't matter if it's wage and hour, if it's pregnancy discrimination, race, religion. Most of the questions will be very similar. When you get to your deposition, you're going to want to be ready to talk about the who, when, why, what, and where. That's the basics. When did each of these items happen that you say was unlawful discrimination? Who did it? And as for each of those things, what did they do? So you might, if you have a supervisor named Mike, you want to be prepared to talk about identifying Mike and Mike's boss Joe and Joe's boss Sally, and be clear about whether or not each of those were involved in the discrimination. You want to be ready to name each and every person that you say engaged in wrongdoing, and you also want to leave yourself a little bit of room to say that there may be people who were acting behind the scenes that you don't even know about. So leave yourself some room there, because there typically are higher level managers that were involved that you don't know about. So 1, be ready to give them a list of the people you say engaged in discrimination. 2, as to each of those people, be ready to identify exactly what each of those people did. 3, be ready to talk about when it happened. And 4, what documents do you have that support that? Are there any emails from any of those people? Did they write any memos? Is there anything else? Did you keep any kind of journals? So before you go into your deposition, it's a good idea to sit down and make out lists like that. Make a list. Who are you claiming were the discriminators? Make a list as to each of those people. What did they do? Make another list as to each of those people and what they did. When did it happen? Were there witnesses? Do you have any documents to support it? Same basic stuff in every discrimination case. Be ready for it. Let me talk just for a second about the type of proof or evidence that commonly comes up in employment discrimination cases. Sometimes our clients get a little befuddled when they're asked what evidence or proof they have that the things that happened were the result of unlawful discrimination. And they look over at us and wonder, well, what does that mean, proof or evidence? There are a couple different ways to prove your case. One is with direct statements. We don't see that very often, but there are supervisors sometimes that are foolish enough to specifically tell you, we're doing this because you're female. We don't hire women in this kind of position. We don't hire people who have physical disabilities for our warehouse. That person is just a little too old to be able to learn this kind of work. That's one type of proof, one type of evidence that commonly comes up in employment discrimination cases that helps us achieve a good outcome. So think about your case. Is there anything that anybody said to you, particularly supervisors or decision makers, that you considered to be a direct statement that indicates a discriminatory motive or intent? Anything at all. If not supervisors, did a coworker quote to you something that a supervisor said? Well, they said they're not going to put any women in sales positions because they're working on construction sites, and the males that work on those sites just aren't going to buy from female salespeople. Anything at all that a supervisor said directly to you or was quoted from someone else as saying that directly touches on the topic of discrimination is helpful. We call that direct evidence, direct proof, and it is very, very helpful in discrimination cases. We don't see it that often because, again, most supervisors know better than to make a direct comment that implicates some protected characteristic like race or gender, but it happens. So you want to think about that before you get to your deposition. Is this a type of evidence that you have available to you? Let's talk about some other types of evidence or proof that can help us. Another common example is to compare yourself to others in the same position as you. Are there coworkers, are there others in the exact or very, very similar job positions that have been treated differently, that have repeatedly been promoted despite the fact that they lack the same credentials that you have, that have been given pay raises across the board and you weren't, that were given other benefits and perks of the position but you weren't? Are there others that are being allowed to do certain things but you're not? So comparing yourself to others is also a useful tool to help a judge and jury see how you've been treated differently. We call this comparator evidence. It's not necessary, but it can be very, very useful if you're able to point to others who are in the exact same position as you and have been treated more favorably. That's in addition to the direct evidence, and let's talk about another kind as well. More broadly, if you don't have direct evidence, a statement specifically from a supervisor, or you can't compare yourself to others in identical positions who've been treated more favorably, there's another type of proof that we can rely on, and that is simply to compare your treatment to the way that others have been treated under similar circumstances. For example, you're being micromanaged. Your boss is hyper-scrutinizing everything that you're doing, but others aren't. There are a range of assignments that are being given out. You always get the worst assignments among all others who perform the same kinds of work than you. You're being left out of meetings that others are being included in. Critical meetings that would help you perform your duties, but you're routinely being left out of those meetings. You're being left off emails. If that's something that's happening to you, that's another common tactic or device that supervisors use to affect someone's job performance in a negative way. Did you have key duties stripped away? Sometimes we have clients who are supervisors whose supervisory duties have been entirely taken away. Under those circumstances, that's evidence of discriminatory treatment. Are you a supervisor in name only now, so that you're performing essentially no work that resembles what a supervisor's done? Are you the only person who's not been given a raise? If you lost your job in a company-wide layoff, are you the only person who actually got laid off? Another example that clients sometimes point to is to show that they're the only black employee, white employee, female employee, male employee, the only disabled employee in a particular work unit. If the work unit is large enough and there's a noticeable lack of diversity, in the employees in that unit, that can also be a sign that the employer or supervisors are hiring in a discriminatory manner. Have you been written up for alleged violations of policy that other employees have been allowed to get away with? Again, another example. So what you're going to want to do, if you don't have a direct statement, if you don't have identical comparators, is to make a laundry list of things that you've been subjected to that you feel amount to discrimination. In this setting, we often have clients who are too embarrassed to include some of the more minor incidents or behaviors they've been subjected to. But what I would tell you is that in this setting, you want to make that list as long as reasonably possible. Obviously, you don't want to include anything that you don't believe was an act of discrimination, but you want to make that list, and you don't want to leave anything off just because you feel it isn't significant enough. Oftentimes, courts are looking for that mosaic or cluster of factors that will help them say, yes, that obviously is discrimination. It could be the one thing you left off that would have tipped the balance. Leave nothing off. Last thing I want to talk about just briefly is damages. In your deposition, you're going to be asked questions about depositions. What kind of income have you lost? How have you suffered emotionally from what's happened? How has it affected your family life or your life with your children? How has it affected your ability to find work in the future? Those are the kinds of things you're going to want to talk about in your deposition. You want to be ready to talk about that, how it's affected you emotionally, physically, if that applies. How has it affected your career search, and how has it affected your family income? So that's all I have for you right now. I hope this has been helpful. Watch it as many times as you need to, and I will talk to you if you have any questions about the things that I've discussed here. Thank you.